All right, that takes us up to our next case this morning, MCINERNEY versus KLOVSTAD. Morning, Counsel. Would you like to reserve some time for rebuttal?
I would, Judge. I'd like to get about 6 minutes or so for rebuttal.
I'll try to give you a signal, but there's also a clock on the bench. You may proceed.
Morning. I'm Patrick McGee. I represent the appellants, Sean and Joan MCINERNEY. Mr. and Mrs. MCINERNEY were the defendants in a lawsuit filed by their next-door neighbors, David and Marsha KLOVSTAD, against the MCINERNEYs and their homeowners association. The lawsuit claimed that the additions under construction on the MCINERNEY home, which were approved by the homeowners association, violated the side yard setbacks, and the KLOVSTADs claimed these setbacks were a minimum of 5 feet per side. KLOVSTAD sought temporary and permanent injunctive relief to require the removal of the offending structure. The lower court disposed of this lawsuit in short order. Within about 100 days, the lower court heard and granted summary judgment in favor of the KLOVSTADs. There are substantial reasons that the summary judgment was erroneous and should not have been entered on this record. And I'd like to touch upon those issues as time permits today. But first, I would like to get to the heart of this matter, which is the trial court's misapplication of the subdivision's restrictive covenant pertaining to side yard setbacks.
Let me ask you a question. This all seems to come down, not the affirmative defenses issue, but as to the main fight here. It comes down to an interpretation of Section 7.31 of the rules. And I think we would all agree that if you look up until the very last sentence of that section, you would say, well, it's 5 and 5, end of discussion. And then the last sentence, as I recall, says something, if there is any conflict with Seminole County or the governing body's ordinances, they shall prevail. What constitutes a conflict? In other words, does one simply have to be, for the two to be in conflict, do they simply have to be different, or do they have to be mutually repugnant, such that you can't, it would be impossible to comply with both?
Well, I think since we're even asking a question of what constitutes a conflict, we would have to say that that term may be susceptible to more than one meaning.
But we can't read an ambiguity into a term unless it's already there, and if it's not a defined term, we have to give it its ordinary meaning. So I guess what I'm asking you is, what does the word any conflict or the words any conflict mean? I mean, does it simply mean if there's a difference, there is a conflict? Or does it mean that they have to be repugnant so that you cannot possibly comply with both?
Our interpretation is that if the two standards are different, that they are conflicting, and the mutually repugnant notion for the term conflict, as I understand it, came from a case, a 1996 case, cited in the appellant's brief and cited to the trial court, that defined the term under that context as mutually repugnant. The interpretation, however, of 7.31 would be based upon the law and facts at the time that this 1996 covenant was executed. So I don't think you can look to the case that came out 10 years later and said the drafter had this definition in mind for conflict of mutually repugnant, and you can't possibly comply with both, if that's the definition of mutually repugnant. I would point out that in application, you can have a circumstance where you're complying with Seminole County but not 7.31, or that you're complying with 7.31 but not Seminole County. For example, the 5 and 5 of 7.31, according to Seminole County, you can't build to within 5 feet of each side property line because one of those sides has to be at least 7 feet off the property line. If you had 6 and 6, if you build it within 6 feet of each side, well, you comply with 7.31, but you don't comply with the county. So the question of which one is more or less restrictive and which one...
Well, one of them is more restrictive, depending on who builds first. I mean, you can, one party under the 7.31 can go up to 5 feet, and to comply with Seminole County, the other party would have to be 7 feet. So one is more restrictive. In other words, Seminole County would allow 3 feet. The other one's less restrictive. It seems odd to me that we should have a notion of who builds there first wins.
Well, I guess the wisdom of having a 7 and 3 rather than a uniform standard might be questioned, but we don't believe that is the deciding issue on how 7.31.
Yes, the Silver Lake Subdivision's governing board and its architectural review committee agreed with you as to the interpretation that you just gave us. Is that correct? I mean, that was their interpretation.
That is correct.
And there's no question about that in the record? There was no...
No. In the first place, the attorney representing the homeowners association argued below as to their interpretation. There are affidavits in file of Mr. Langio and Mr. Edom that address that issue, that they believe they are interpreting the 7.31 restriction as written when they defer to Seminole County, because there is a difference. Additionally, there's an affidavit in the record in connection with the summary judgment hearing from a general contractor who was responsible for the design and building the MCINERNEY additions. And he discusses the reason there's a conflict between the two, that complying with one does not equate complying with the other, that none of the numbers are the same. It's as if with 7.31, and you have these differences in opinion, as if you have one of these Rorschach ink blot tests, where you're showing 7.31 to Ms. Meeks and the trial court judge, and they say it's a waterfall. And you show it to everyone else. You show it to me, to the attorney who gave the written opinion for the homeowners association, to the homeowners association president, to the board of directors, to the general contractor, and say, well, what do you see? Well, I see a moose. Well, but the problem here is not that people are seeing different things in looking at 7.31 and different interpretations. The problem is that the judge who saw the waterfall, as Ms. Meeks said, hey, anybody that sees a moose, they're not rational, they're not reasonable. You can't possibly see anything else than what I see in 7.31. And with this panel, the question is, what do you see when you look at 7.31? When you read that language that says, and it's the sentence, Judge Ortfinger, that you referred to, if there is any conflict between this section and the applicable zoning regulations of the property governing authority, said zoning regulations shall take precedence. Well, what does that mean? Does that mean we're going to apply both standards? We're going to pick out the most onerous side yard restriction on this side and apply that, and the most onerous restriction on this side and apply that, so that we have Seminole County on one side and 7.31 on the other? Or does it simply mean if none of these numbers match on the side yard setbacks, the drafter has told us what to do? Let's go to Seminole County. Seminole County shall take precedence. Now, in this particular instance, we have the KLOVSTADs confusing the issue a bit by introducing a rule of law with the lower court that says there's a legal principle that the homeowners association cannot have a less restrictive covenant than the governing authority, but it can have a more restrictive covenant. So it is possible for the homeowners association with their restrictive covenant to say, I don't care if Seminole County says 7 and 3, we say 10 and 10, and that is enforceable. The question, though, is how would that rule of law be applied in this case, and doesn't have any application whatsoever? The drafter has not said that we wish our restrictions to supersede Seminole County, whether they're more or less. The drafter said, if there's a conflict, we're deferring to Seminole County. I'm not saying apply both of them, apply the more restrictive. The drafter could have easily said that, but the drafter did not. But no one has proposed an application of 7.31 that would cause 7.31 standard to supersede the Seminole County standard. 7.31 defers to Seminole County. But what the KLOVSTAD say, however, is that the only logical meaning of 7.31 is that it never defers to Seminole County unless by applying 7.31 setback you would violate this legal principle. So, in other words, do not defer to Seminole County unless applying 7.31 would violate Seminole County's restriction. That's just not what 7.31 says.
If we agree with you that last sentence creates an ambiguity, in your mind, does that mean you win, or in your mind, does that mean you get a trial to admit parole evidence to find out what the intent of the drafters were?
In my mind, we win because of the rules for construing restrictive covenants. And we've stated this in the briefs, that in construing a restrictive covenant, the ambiguities are decided against the person seeking enforcement, against Ms. Meek's clients. So if it's ambiguous and we offer a reasonable, a rational, a possible interpretation, then that ambiguity is decided in our favor, and we win. There are also other principles that restrictive covenants are to be construed in favor of the free use of land. I've cited those principles. So if there is an ambiguity, yes, Your Honor, I would say that we win, and we win here. But we would like this court to say that 7.31 means this, means what we say it means, a conflict, that there is a conflict between the two standards because none of the numbers match. And it is de novo review of this interpretation of 7.31. But at a minimum, if there is an ambiguity, summary judgment should not have been entered. And that's why I'm addressing the interpretation issue first. Of course, there are issues regarding summary judgment. Our preference would be to not get this case remanded solely on technical grounds, that summary judgment should not have been entered on this record, and then be in the same spot, and the judge say, okay, let's try it, and I'll come up with the same result, and we'll be right back here with the same interpretation. We think that it would be appropriate for this court to make a determination that there is a conflict between 7.31 and Seminole County, because none of the numbers match, and that we don't have to make up a definition of the term conflict, a special and limited definition that's found nowhere in the declarations, that's found nowhere in Florida law, in order to achieve this result that we had in the lower court, a result that was not intended by the drafter under the plain language of 7.31. The drafter wanted to say comply with a more restrictive setback, with the greater setback, comply with the setback that has the higher number.
Yes, the one problem I think the trial judge probably had with your interpretation is that your interpretation seems to make 7.31 completely meaningless. In other words, the only time it would apply would be if the Seminole County setback requirement was exactly the same as the Silver Lake subdivision setback requirement. And if that's true, why not just say use the Seminole County setback requirement, since that's the only time that this different one would apply. So, I mean, that is problematic and a little troubling to me. Why would you write a provision that is completely meaningless and only means follow Seminole County?
Well, the record explains, especially in the depositions of the Seminole County officials that were taken and in the record and in the argument, but explains how the restrictions or the standards for setbacks are determined in Seminole County for this PUD. This subdivision is a planned unit development. They are determined by negotiation between the developer and Seminole County. In the record is what a revised commitment, and in that revised commitment, there is this 7-3, this negotiation between Seminole County and the developer, and there is an agreement that is signed by the developer, the crossings, and Seminole County Board of County Commissioners. that sets the 7 and 3. That's by negotiation. Now, the covenant itself has 5 and 5, but defers to Seminole County. Now did
the developer draft 7.31?
That was signed by Gino Palucci. The covenants themselves. The revised commitments were signed by the developer, Mr. Edgerton, I believe it was, as trustee, along with the crossings and a representative of the Seminole County Board of County Commissioners. And in that instance, none of the parties were the same. However, I would point out that if you, in 7.31, by drafting it the way it was done, no matter what the county did, the homeowners association would still have a hand in enforcement and controlling variances, so that you're not just saying whatever the county says, that's okay. Well, the county is going to grant variances if on occasion, if it gets a request. The homeowners association now can enforce that 7 and 3 that's in there and make sure that that is the minimum between homes. Also, you would the drafter could have been traveling under the understanding that it's easier to get a commitment, a revised commitment, a second revised commitment to get what the developer wants in connection with this development than it is to amend the covenants themselves. So even by deferring to Seminole County, if there is a conflict, the homeowners association retains a hand in enforcement and controlling variances. So there is some method to the madness in this case that does make some sense. Besides that, it says what it says. It says if there's a conflict, we defer to Seminole County. This court.
We're down to about 4 minutes. If you
yes, Your Honor. I will reserve. Thank you very much.
Good morning.
Good morning. May it please the court. I'm Mary Meeks with the law firm of DeCubelis, Meeks & Uncapert in Orlando, and I represent the appellees before this court, the KLOVSTADs, who are the plaintiffs below. To me, this is really a fairly simple case. We talk about the law in the form of codes and regulations of the county, and we're talking about a contract. A restrictive covenant is nothing more than a contract.
If we agree that there's an ambiguity in 7.31, do you agree that under Lathan and Snyder and the other cases that talk about how you construe an ambiguity in a restrictive covenant that you would lose?
No, I don't. I believe that there is a rule that if a court makes a finding as a matter of law that there's an ambiguity, there are rules as to strict construction, but there's not a rule as a matter of law that it has to be construed in a certain way.
Well, the rules are that it has to be construed in favor of free and unrestricted use of land, and it would have to be construed against the party claiming the right to enforce the restriction. To me, that says that if there's an ambiguity, the party, the other side wins, in other words.
Well, I don't believe that is entirely correct in every case. I think if a court can make a finding as a matter of law that there's an ambiguity, and given that ambiguity with a strict construction, that it means a certain thing, as opposed to, and this issue came up in the trial court, that there being some evidence of the actual intent of the drafters. Now, I think the evidence of that intent the law requires would be strictly construed. I think that it certainly tilts things towards the property owner who is hoping not to have to comply with the restrictive covenant, but I don't think it's necessarily a determination as a matter of law in this case if there is an ambiguity. But Judge, you raised, I think, the exact question that hits the nail on the head that is determinative of this case, and that is, as the trial court said, if you accept the MCINERNEY's proposed interpretation of conflict, then it renders the whole covenant completely superfluous. The only interpretation of 7.31 that gives meaning to the entire covenant is the one that the KLOVSTAD's proffer, which is that conflict means mutually repugnant, or as some of the specific restrictive covenant cases say, that conflict means that you cannot, a homeowners association cannot impose by contract a requirement that is less restrictive than what the law requires by the governing authority. And the cases that we've cited generally for that definition of conflict as mutually repugnant Those cases go all the way back to, I believe, 1971. So as far as the timing, 1979, as to the general definition. But we've cited at least 2 cases that are restrictive covenant cases that apply the definition where it says by contract, a restrictive covenant can create a contractual covenant among homeowners that is more restrictive but not less restrictive than what the governing authority requires. And that's the O'Brien case, which is from 1971, and the Toller case, which goes all the way back to 1957. So that principle of law, and specifically with respect to restrictive covenants, goes decades well before the particular covenants in this case were drafted. So as the trial court said, that was the generally accepted definition of conflict. That was the generally accepted concept of what a restrictive covenant can and cannot do at the time that this restrictive covenant was drafted. So that should be read into the intent of the drafters.
What about Mr. McGee's argument, though, that it isn't superfluous because you could go request a variance from the county?
Well, that's certainly, if we're talking about looking at the actual expressed intent of 7.31, is nowhere in the covenant itself. The covenant says, and the rules of construction say, if a restrictive covenant, if the intent is clear, there's a very strong presumption of validity. In this case, the first part of it is very clear. They say, we want a minimum 5-foot setback. And then the second part, unless there is a conflict, in which case Seminole County governs. Well, if you're going to give meaning and effect to both parts of that sentence, the only thing that can mean is we want a minimum 5 foot unless there's some law out there, in this case Seminole County, that says that you cannot do that. And this whole idea that you can go to the county for variances, there's nothing in the restrictive covenant that addresses that issue. This has become far more complicated than it is on its face. Mr. McGee uses the
But Mr. McGee is correct, I think. Wouldn't you agree that the restricted covenant could be enforced, or even if the county was inclined to grant a variance, the subdivision could keep at least that 3-foot setback as required by Seminole County, because the county can't grant a variance to a restricted covenant. So that does seem to give a purpose for that section.
Well, I think
Actually, that's correct. I mean, the
certainly
subdivision
the county can grant a variance.
The county could grant a variance, but the subdivision could still enforce the covenant so that the variance wouldn't have any meaning.
Well, I think the overriding point here is that each landowner or each property owner that buys into Silver Lake, they have 2 sets of authority that they have to comply with. One is the county. Another is a contract that they signed. When the McInerneys bought their house, they agreed, they signed a contract with all of their neighbors that they would not build any structure any closer than 5 feet to the property line. And everybody else that bought into the property relied on that. But they also still have to comply with the county regulations. And I agree, with Judge Orfinger, it gets a little interesting here, this whole idea of, I think in one of the depositions I even asked the question, the early bird gets the worm here. Under the set of facts that these homeowners have, it really does matter who builds first. And in fact, the Kathy Fall, who was the senior planner whose deposition was taken, actually gave the example where operating only under the Seminole County regulations, that you could have an instance where if each of your neighbors was first to the punch and they both built within 3 feet on your side, then you're stuck with 7 feet on both sides. And so the McInerneys argue that it's just not fair for them to have to comply with 7 on one side to please the county and 5 on the other side to comply with the restrictive covenant, because that's too onerous. When in fact there certainly could be circumstances where just complying with the county regulations, you could legitimately be stuck with having to comply with 7 and 7 if your neighbors beat you to the punch on their 3. But again, I think, and the trial court was very clear, that the only interpretation that he could come up with that gave meaning and effect to all of the language in the covenant is we want a 5-foot setback unless the county says that you can't do that. And in this case, as between the McInerneys property and the KLOVSTAD's property, the county says you can do that. They're perfectly happy with a 5-foot setback. Again, Ms. Fall, the senior planner, testified to that. She said there was no problem at all with regard to having the 5-foot minimum setback on this side of the property because I think her testimony was there was no problem because 5 foot is more than 3 foot, and we always allow more and not less than.
But that doesn't really solve the problem that you were just mentioning, even if it's 5. So if you're building between 2 houses, both of which are built up to 5 feet, your interpretation of the restriction would still require that fellow in the middle who's going to build the last house be 7 feet on both sides.
Absolutely. And that satisfies the intent of the restrictive covenant and complies with the county. And this was a point that the trial court made repeatedly is, remember, these restrictions are just establishing minimum setbacks. They're not maximum setbacks. They're not required setbacks. You don't have to have 3 and 7. You don't have to have 5 and 5. It's entirely dependent on the circumstances. And so the point is, as long as you're complying with both, you're okay. So a minimum 5 foot, according to the covenant, in a situation where the county requires 7, there's nothing wrong with that. So you're still satisfying both. So you're satisfying the minimum 5 foot, certainly, if you're satisfying the county's 7 foot. And I think that was another point that the trial court really focused on is, and I think he used the term that got misinterpreted as the case went on, where he said the county's not hung up on the 3 and the 7. The county does not require 3 and 7. The 7.31 doesn't require 5 and 5. Those are minimums.
Let me ask you about the affirmative defenses. Wouldn't you agree that that a right to enforce a restrictive covenant can be lost by waiver or acquiescence as a matter of law?
I would agree generically that is possible. So let me break it down into 2 different categories. First, as to any waiver or estoppel that may have been created by acts of the homeowners association or by the developer. I don't think that's their argument, but the case law is clear that the homeowners association cannot waive a restrictive covenant on behalf of each of the homeowners. And I think the real issue here.
So I agree with you. It's to the real issue.
Okay, so I think the real issue they argue is somehow did the KLOVSTADs waive, or are they stopped to assert 7.31? In this case, because Mr. KLOVSTAD supposedly reviewed some plans.
Let me ask you this: if you can waive enforcement of a restrictive covenant under some circumstances, it would seem to me that the circumstances that the opposing party allege occurred here and state and affidavits occurred here would be that kind of circumstance. In other words, you have a party that looked at plans that showed a 5-foot setback according to them and nodded their approval, allowed it to go to the board, allowed it to get approved, waited until a month after construction started, and then after a lot of money's been spent, a lot of resources were spent, and the construction began, that for the first time they then object. Why wouldn't that constitute a waiver? Because
of the standards that have been established by this court. And I think the seminal case, which I proffered by supplemental authority, is the Mizell case, which is a case, very recent case, I think from 2002, from the 5th District Court of Appeal, which gives the specific standards to find a waiver or estoppel in the specific context of a restrictive covenant case. So first of all, with regard to waivers, the Mizell case says, in order for there to be a waiver of a restrictive covenant, it must be a long, continued waiver and a conscious acquiescence with regard to a persistent, obvious, and widespread violation. And in that case, this court reversed a trial court's finding of waiver and actually entered judgment as a matter of law that there was no waiver, where in that case the plaintiff took no action for 1.5 years with regard to a restrictive covenant that prevented mobile homes from being placed on the property. In that case, there had been some temporary exception made for the defendant to have a mobile home on their property temporarily while they built the home for a specific period of time. They apparently decided at some point, instead of building the home, they were going to move in a larger mobile home. 1.5 years after they had the time frame had expired that they were told they could have the mobile home on the property, the plaintiff brought the action.
Didn't Mizell deal with estoppel by silence?
Well, that's estoppel. So there's 2 different issues here. There's waiver and estoppel. So as to the waiver, the standard was, first of all, there has to be knowledge. And at best, the argument here by the MCINERNEYs is constructive notice that Mr. KLOVSTAD looked at some plans that haven't been proffered or identified that
I thought that
supposedly
the,
showed.
now, I thought that the affidavit said that the only plans that were given to the homeowners association showed the 5-foot setback.
Even assuming that to be true, there's no testimony, no evidence as to, I mean, the plans are, you know, this thick. What exactly did Mr. KLOVSTAD look at? There's not even been an argument that Mr. KLOVSTAD knew, supposedly, that the plan showed it was building within, encroaching the 5-foot setback. Their argument all along has been, he looked at the plan supposedly showed that, so therefore he has constructive notice. That's different from knowledge, and certainly, in addition to that, waiver requires a conscious, an affirmative act, a conscious acquiescence. If he had signed a piece of paper or said, it's okay with me, you're not violating the covenant, go ahead and build, then maybe we'd have an argument to determine on remand below. But their whole argument has to do that, first of all, constructive notice, which is as a matter of law not sufficient for waiver or estoppel, and an intentional relinquishment of his rights. And that certainly never took place here. So the reliance on silence, again, Mizell addresses that issue as to waiver and estoppel, and this court held that you can have no estoppel by silence where the parties have equal knowledge. So clearly in this case, they're relying on constructive notice and then silence after the constructive notice. And this court, as well as other courts, have held that you cannot have a waiver or estoppel where the other party has the exact same knowledge. So those theories apply where my guy has some knowledge or notice that the other guy doesn't have, and by not telling him that, lets him proceed to some detriment. Well, these were the McInerney's plans. Surely they knew that they were building closer than 5 foot to the property line. So even assuming that Mr. KLOVSTAD had notice or even knowledge of that, and then didn't speak up for a couple of weeks until the actual construction began, as a matter of law, that could not possibly constitute a waiver or estoppel under the standards that this court very clearly set out in the Mizell case. So it is our position that even taking the evidence offered by the McInerneys on this issue in the light most favorable to them, that there is no way possible that those facts could constitute a waiver or estoppel under the standards set forth by this court.
Is there a factual question regarding the balancing of conveniences? In other words, the slight benefit that the KLOVSTADs would get by the extra 1.5 feet, which they apparently didn't even realize or couldn't even tell until they got out with the tape measure and measured a month after construction started, versus the substantial detriment to the McInerneys now having to tear down what they've built?
Well, first of all, I would clarify the record. It was when that outside wall actually started to go up that they knew something was wrong. This was Thanksgiving. They were very alarmed by that. Now, yes, they went out with the tape measure to make sure, but as soon as the foundation for that wall went in, they knew that was too close. But before they started making phone calls, yeah, they went out and measured it. But to answer your question, to me, this is perhaps the only arguable point addressed on the appeal as far as the defense of the balancing of conveniences. We rely on the case of Daniel versus May, which is a restrictive covenant case. It's a setback case. And in that case, the court held that the equitable defense of balancing of conveniences does not even come into play unless the court makes a specific finding that the harm to the plaintiffs is de minimis. So you don't even get into that, well, it's only 1 foot versus it costs however many thousands to move the wall, unless the court first makes a determination that the harm to the plaintiffs is de minimis. Well, that makes any evidence proffered by the McInerneys completely irrelevant to that first step in the process. So in this case, the court looked at, there were affidavits from the KLOVSTADs, there were pictures in the record that showed what it looked like built this close to the property. There were petitions proffered to the court that had been signed by dozens, I think some 75 or 80 other homeowners, demanding that the setback, restrictive covenant setback, be enforced. And the Florida Supreme Court and other courts, as a matter of law, say there is a presumption of irreparable harm that occurs by violation of a restrictive covenant. And based on that, this court made a specific finding that the harm to the KLOVSTADs is not de minimis. Going back to the Daniel case, so again, that's a setback case. So that court found the balancing of conveniences doctrine did not apply at all in that case, because There was no finding the harm was de minimis. So first of all, they've implied that violation of a setback, certainly generically in and of itself, is not necessarily de minimis. And in that case, the setback, I think, was 15 feet, and the building encroached into 6 feet of that. And that they clearly found that not to be de minimis. In this case, you have a 5-foot setback, and they built an encroachment into nearly half of that. So I don't think it's accurate to count the feet. I think the more accurate definition is what they want to do is to encroach into almost half of the setback that clearly is expressed in these restrictive covenants. And I think that the finding by the trial court that harm to the KLOVSTADs is not de minimis, and therefore you don't even get to any balancing. I think the de minimis doctrine applies where you may have an instance of somebody intending to comply with a restrictive covenant, and maybe they built it over the line by a couple of inches accidentally. By the time they learn that, it's going to cost them thousands of dollars to move it. Perhaps that is an example of a de minimis. But in this case, you're talking about encroaching on nearly half of the covenant that's required and agreed to by a collective contract here among all of the homeowners. So I think that the trial court, if this court finds the trial court's specific finding that harm, in this case to the KLOVSTADs, is not de minimis, then that takes care of that affirmative defense as a matter of law, as we believe all of the affirmative defenses were correctly determined to be legally insufficient as a matter of law. So it is the KLOVSTAD's position that 7.31 means exactly what it says. We want a setback of 5 feet here, unless, under some circumstance, the governing authority says that's not allowed. And in this case, between the two parties, the KLOVSTADs and the MCINERNEYs, the covenant requires a minimum 5 feet that is completely consistent with the governing authority's requirement of a minimum of 3 feet. So we would ask that the court affirm the summary judgment in all respects as to interpretation of the covenant and the affirmative defenses.
Thank you, counsel.
One of the last things Ms. Meeks says was that we want 5 feet on each side, unless Seminole County says that's not allowed, in which case then we trigger some of these actions from 7.31. The record is complete with the facts that show that you cannot build to 5 feet and 5 feet. You cannot do what 7.31 says, the 5 and 5, because you can't get a building permit from Seminole County. That's in the record. You can't do that. They won't allow it. They would allow it on one side, but not the other. You have to go 5. If you're going to go 5 feet on one side, you have to go 7 feet on the other. Now that's a greater restriction than either Seminole County or 7.31. That's applying both standards to the property owner. That's burdening the property owner with greater restrictions than either standard. The minimum distances between the houses are greater than either standard. That's not a proper interpretation of 7.31. The problems that the KLOVSTADs had is that they originally argued to the court in the temporary injunction hearing, you can do 5 and 5. And Seminole County says that's perfectly okay with Seminole County, and the judge said that in his ruling at the temporary injunction hearing, that all Seminole County cares about is a 10-foot separation between the houses. They're not hung up on 3 and 7. They'll let you do 5 and 5. Well, the records show that that is not the case. You can't do that. So once we find this conflict, under Ms. Meek's definition of conflict, what do? Well, we'll apply Seminole County on one side, because that's more restrictive on one side, and we'll apply the Homeowners Association 7.31 on the other side, because that's more restrictive. We're going to pick and choose between these standards and take the most restrictive number on each side of the lot and apply those. That's not what 7.31 was intended to do. The drafter did not say you shall comply with both. The drafter did not say you shall comply with the most restrictive on each side of your property. The drafter said if there's a conflict, and under Ms. Meek's definition of conflict, her definition of conflict, there is a conflict. If there is a conflict, apply Seminole County. It shall take precedence. We did comply with Seminole County. We have complied with Seminole County. It is a rational and reasonable interpretation of 7.31 to say that there is a conflict because none of these numbers match, and that you cannot get a building permit if you go to within 5 feet of each side of your property, and that Seminole County should prevail. The clause should not be interpreted to mean that you shall comply with both 7.3 and Seminole County. It would have been easy to so provide. The lower court exceeded its role in the summary judgment and meaning the 7.31 that's not found within the four corners of the covenant. The lower court improperly imported additional limiting terms to 7.31 by construing the Seminole County setbacks to take precedence only if Seminole County setbacks are more restrictive than those found in 7.31. If the drafter meant to restrict 7.31 in such a manner, the limiting language could have been easily added in this case, but it was not. Our points regarding the summary judgment and the heavy burden on the plaintiff in this case of moving for summary judgment before an answer was filed, that's all laid out in our brief. The conflicts in the record, the fact questions in the record are laid out in the brief. If there's any ambiguity, with all inferences in favor of my clients in the record, summary judgment should not have been entered. But moreover, there's a misapplication of 7.31. We would ask the court to review 7.31 de novo and correct the trial court's misapplication and misinterpretation of that statute, of that covenant, so that it does not require my clients to comply with both Seminole County and 7.3.
Thank you, counsel.
Thank you very much.
All right, we'll take a